Honourable Ginny Anderson.
Thank you very much, Madam Chair. Thank you for the opportunity. I'll be upfront, Madam Chair. There's been a number of people waiting a long time for this legislation to pass, so we don't intend to hold this up. We want it to proceed because it has been well overdue in being implemented. So I will briefly speak to the 3 amendments in my name that were tabled. All 3 amendments relate to Clause 4, new section 21601B, and that's in relation to the mental component for the offence of stalking. Mr Chair, one of the main issues that has been repeatedly raised by advocates within the sector is that quite often the accused stalker in situations where there is an ongoing repeated pattern of stalking, that person who is doing that behaviour is often deluded or unaware of the impact on the victim. Sometimes they are, but sometimes they aren't. And so our concern, and it is not just on the side of the House, it is in with advocates in the sector as well, is the mental element of knowing may not be able to capture a prosecution, because quite often someone thinks that their affections is wanted or even reciprocated when they are not. This tabled amendment amends the Crimes Legislation Stalking Harassment Amendment Bill and I've provided 3 different options for the Minister to consider in the 3 separate amendments. And that would be to replace knowing with, the first option is to having reasonable grounds to believe. The second one is without believing on reasonable grounds, and the third one is when a person knows or ought to know, so a reasonable person test being introduced as the mens rea component to this offence. And the primary reason that is, Mr Chair, is that we believe that it will be difficult to prove that the person was knowing that they were likely to cause fear or distress. To prove that a defendant did know their behaviour was causing fear or distress would potentially require proof beyond reasonable doubt that the defendant knew that they engaged in a pattern of behaviour that caused that fear and distress to another person. So, for example, if they were intoxicated, if they were cognitively impaired at the time, the defendants could argue that they did not knowingly engage in that behaviour that causes fear or distress to that other person. So while we are strongly supportive of this legislation proceeding, we do believe that the mental component of this offence could be strengthened by replacing knowing by a reasonable person test to make sure that in a situation where the accused is saying they didn't know or they weren't aware of the impact of their actions, that would not result in there being not a prosecution when there should be one. And this is specific to this offence for the fact that potential offenders that will be captured under this legislation are more often than not often in a rational state about the reciprocation of their feelings to another person. So we believe that it's quite a specific grounds, and we've had direct feedback from previous victims and from advocates within the sector that this change would strengthen the legislation and make it stronger for victims to be able to have their safety protected and to prevent situations where stalking is ongoing.
Thanks for watching. Make sure you're subscribed to our Facebook, YouTube, Twitch, Instagram, TikTok. Who's got the order, baby podcast?